IBP vs. Zamora. GR number 141284, August 15, 2000. Facts: in view of an alarming increase in violent crimes in Metro Manila, robberies, kidnappings, carnappings, President Joseph Ejercito Estrada issued a verbal directive ordering the deployment of the Philippine Marines to join the Philippine National Police (PNP) in visibility patrols. The IBP questioned the validity of the deployment and utilization of the Marines to assist the PNP in law enforcement. Issue number 1. Whether or not the President's factual determination of the necessity of calling the armed forces is subject to judicial review. Held, no. When the President calls the armed forces to prevent or suppress lawless violence, invasion or rebellion, he necessarily exercises a discretionary power solely vested in his wisdom. Under Section 18, Article 7 of the Constitution, Congress may revoke such proclamation of martial law, or suspension of the privilege of the writ of habeas corpus, and the court may review the sufficiency of the factual basis thereof. However, there is no such equivalent provision dealing with the revocation, or review of the President's action to call out the armed forces. The distinction places the calling out power in a different category from the power to declare martial law, and power to suspend the privilege of the writ of habeas corpus. Otherwise, the framers of the Constitution would have simply lumped together the three powers and provided for their revocation and review without any qualification. The reason for the difference in the treatment of the said powers highlights the intent to grant the President the widest leeway and broadest discretion in using the power to call out because it is considered as the lesser and more benign power, compared to the power to suspend the privilege of the writ of habeas corpus and the power to impose martial law, both of which involve the curtailment and suppression of certain basic civil rights and individual freedoms, and thus necessitating safeguards by Congress and review by the court. Issue number 2. Whether or not the calling of armed forces of the Philippines to assist the Philippine National Police in joint visibility patrols violate the constitutional provisions on civilian supremacy over the military. Held, no. The calling of the Marines in this case constitutes permissible use of military assets for civilian law enforcement. The participation of the Marines in the conduct of joint visibility patrols is appropriately circumscribed. It is their responsibility to direct and manage the deployment of the Marines. It is, likewise, their duty to provide the necessary equipment to the Marines and render logistical support to these soldiers. In view of the foregoing, it cannot be properly argued that military authority is supreme over civilian authority. Moreover, the deployment of the Marines to assist the PNP does not unmake the civilian character of the police force. Neither does it amount to an insidious incursion of the military in the task of law enforcement in violation of the Constitution.